I do not have any statistics, but indication that people retire at 70 and within a short time, they join the other side. The work of a judge is a stressful one. You burn the midnight oil, you sit up and write judgments. So I think that 70 is good enough. And let me say, even in other jurisdictions where they have 75, when you are about hitting 70, you can choose to be a supernumerary, which means that you've cut down your work, you choose what to do, and they'll rather give it to those who are young. So as my brother who once said here, I think the 70 is good enough. Let's stick to it. So that when we retire, we can have time to spend with family. Thank you.
Chairman, my second question is about our districts with courts and the lack of judges. I think this is about my third time of asking this same question. What is your suggestion on how we will be able to get judges to, I should say, the 216 or is it 17 districts as at now, so that we don't continue to delay cases, denying justice to people?
Thank you, Mr. Chair. I think the occupation of a judge work must be attractive. There are many lawyers who may desire to be judges, but if you join the bench and after 6 months you've not been paid because your name has not gone on the system, within that 6 months of your service, how are you supposed to support yourself? So let's make the job attractive. As we speak, my beloved Bogoso has a court yet to be inaugurated, and I'm sure the people there are yearning to have a judge. But if people are not willing to join the bench because the package is not attractive, speak with those on the lower benches, their situation is not the best. So let's make the job attractive, and I think we'll be able to have the best of the brains to join the bench for the benefit of our nation. Thank you.
Thank you, Mr. Chairman. I wish you all the best.
Honorable Jerry Ahmed, you have the floor.
Thank you, Chair. My Lord, congratulations to you, and you're welcome. My Lord, I've just perused Article 1461, and it talks about justice of the Supreme Court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior. I'm not going to talk about or incompetence. I want, in your view, to tell me what would constitute stated misbehavior. If you have about 5 of those or less, it's fine.
Thank you, Mr. Chair. I think this is not defined clearly, but I think what is a misconduct, all of us, when we see one, we should see it. There is a Canadian case called Mary DeBow. What was deemed to be a misconduct was a judge sitting who became so frustrated with people who are in her court, and she made statement that they are lazy, they don't want to work, all they have to do is to engage in criminality. That statement was deemed a misconduct, and she was removed from the bench. Okay? I've been a member of an investigative body where a judge in the Upper East was sitting and didn't have a copy of the minerals and mining law. A lawyer agreed that, my lord, when I get to Accra, I'll get you one. When the lawyer got the law, the mistake the lawyer made was, instead of taking it to the registrar, gave it to the client, and the client was going to give it to the judge. Somebody saw the person entering the judge's home, and a committee was set to investigate this as a misconduct. Of course, the committee eventually exonerated him, because we know that the litigant should not come to your home. So I think that many of the things that judges are required to do based on the ethics, if you go contrary to it, clearly may constitute a misconduct, depending on the facts to be determined.
Thank you very much, my lord. So my understanding is that stated misbehavior depends, or misconduct depends on the facts to be determined. But these facts, as we have not seen the definition of stated misbehavior, in your view, what should we do about it? Should we define what stated misbehavior is?
I think at this stage, at this moment, Article 146 has become a topical issue. Maybe it's high time we have a CR or regulation, so some of these things can be properly defined, and everybody will know the parameters of what these are. Thank you.
My Lord, this also brings to mind, I know you are a very, the kind of person who is very technologically inclined. I mean, I remember the last time I was before you was when you were in the High Court, and you had your own computers and things before you. So I labeled you as a gadget master. I want to find out, with the advancement of technology, the president is not in town, he's not in Ghana. The vice president is not in Ghana. The Right Honorable Speaker is not in Ghana. At what stage would technology be beneficial to all the three that are not in Ghana? What would be your recommendation? Who is the president? Or who can be termed as the president?
I think, if I understand your question, if the president, for example, is in Geneva attending a UN program, and the vice president is here, can we clearly say that out of the jurisdiction based on technology now, the person is absent? I am of the view that if matters can be regulated from there, depending on the situation, because the absence within the jurisdiction may not be the basis to say that the person is absent. I think we are in a situation where even judges, we should have a situation where a panel, one may be somewhere, if they can be linked up virtual to hear a matter, should be possible. So that's how I look at it. We can all take advantage of technology to answer some of these nuances. Thank you.
So would that be part of the recommendations you would pass on with reference to your issues on constitutional review?
Yes, I think some of these parameters must be clearly defined, and once they are distilled out plainly for everyone to understand that in such situations, the president or the vice president ought not to be deemed to have been absent and can still carry on his or her job, that will be very much welcome, so far as it has some statutory backing. Thank you.
Very excellent. My Lord, I just want to find out, how can the Supreme Court ensure some balancing with reference to, or in respect of, freedom of expression with the need to combat cybercrime and online misinformation?
I think in an earlier question, I quoted Lord Denning in British Steel Corporation. You know, I think free speech is not cheap. People should have the right to express themselves. But in expressing yourself, it should not be an avenue to abuse people and to defame people. We should recognize that online abuse is more serious than the old traditional way, because whatever you write here could be read in Australia or my made-up town of Ackaah-Boafo. They will read it there, and it may be online, it will never go. So I think once we want to allow people to have free speech, there must be responsibility attached to it. And so I believe in free speech, but free speech must be with some responsibility. Thank you.
Does that mean that people should be extremely careful as to what they say and when they say and where they say them?
I would say that social media has not done away with our old tort libel laws. They are still applicable. So that if you choose to go contrary to the law on social media, as I said, in Pakenham versus North Carolina, social media was deemed to be like you sitting at a public park and you uttering something. If that will be taken as serious, if you do it on social media, it should be taken as serious. Libel laws are still applicable. Let's be very careful about what we put on social media. If you go contrary, somebody ought to sue you. The court will hear that. Thank you.
Well, this will be my final question. Would you recommend that the Chief Justice's functions of being a judge and an administrator should be decoupled, should we have just the Chief Justice doing the functions of a judge? And should we have an administrator doing the functions of just the administrator?
Thank you, Chair. Insofar as the Chief Justice is seen to be the head of the judiciary, I think that decoupling may not be necessary. I think it happens virtually everywhere. It ought to be a balance on the part of the particular Chief Justice as to how much work he or she wants to engage in the courtroom and how much work he or she wants to engage in administratively. So I won't call for a decoupling of that. Thank you.
I was looking for that. Thank you very much, and I wish you very well. No further question.
It's not a Tennyson.
My Lord Ackaah-Boafo J. You're welcome. JSC soon to be. I'm very proud of you. I lost a case before you.
Is that your question?
I appealed, but I know I won't succeed because your judgment was sound. I tried the matter on a very thin line, but you distilled the law, and your writing style as a judge, it's unique. My question will come. You are in the mood of Justice Francois and Taylor and Co. And I urge you to keep it up. You write extremely well. Now, the question has been posed to your other colleagues regarding the non-definition of misconduct being a basis upon which a judge can be removed from office. But I differ. So here is my scenario. You judges have a code of conduct for judges and magistrates. And Rule 2 of that code says that a judge must avoid impropriety and the appearance of impropriety in all of the judge's activities. That's contained in page 3 of the Code of Conduct. Is it not the case that where this is breached, this will amount to a misconduct? You are a lettered man. You're a man of letters. A code of conduct, if it is breached, if any of the rules in the code is breached, it will amount to a misconduct. You agree with me?
Thank you very much, Chair, and I'm humbled by your initial comments. Let me say this. Yes, it might amount to misconduct, but should that misconduct, depending on the facts, be the basis for removal? In other jurisdictions, judges may receive a reprimand. Some may receive you writing an apology. Some may receive counseling. So I think that, yes, depending on the facts, the misconduct will be established. But would that amount to a misconduct that leads to a removal? It's another matter. Thank you.
Mala, you took the wind out of my sail, because my second question would have been, that's why I said, if any portion of the code is breached. Now, to breach a code, it means that will have to be established based on the facts and the evidence. So when it is established that the code has been breached, then the second stage will be, what are the penal sanctions applicable to the breach of that particular code? So once we have a code of conduct for judges, every other matter regarding the removal of a judge will have to be based on that code of conduct. And so we'll leave this matter. Now, my issue is this. I'm waging an advocacy here, and it's in respect of career magistrates. Career magistrates don't receive equal pay for the work that they do with their professional career magistrates. Will you join me to ensure that they receive equal pay for equal work? And by way of providing further and better particulars, professional magistrates, they are entitled to official accommodation, official vehicle, official everything. The career magistrates doing equal work are not entitled to official accommodation, they are not entitled to official anything, save for the nominal salary. And I believe that that amounts to great injustice being done to them, especially when they don't have the opportunity to progress. I think 3 of your colleagues who have been here progressed from the magistracy all the way going to the Supreme Court.
Mr. Chair, well, I think I will join you insofar as they do the same job, but ultimately, you are here, you are the one who makes the laws. I'm not sure any career magistrate mount a court without a statutory backing. If you, who is waging this advocacy, is of that view, then I will respectfully ask that you ask your colleagues to join you so that you have a law that will support the position. But on the periphery, I agree that if people are doing the same work, then they should have some benefits, because in other countries, Uganda and other places, they still use some of these magistrates, and they have a better way of treating them. Thank you.
My Lord, your answer gives me opportunity to come back. We have enacted the law. That's the labor law, the Labor Act. Labor Act is very simple, that you must pay a worker for the work that he's done. You don't discriminate. So equal work, equal pay for equal work. Now, I've run into problems because I'm rather told that it's a policy of the Judicial Service. And I've raised the breach of the Labor Act many, many times at the committee level. So while you've given me an indication, I may have to push this further and actually insist at the committee level that that policy must align with the terms of the law. So I thank you for your opinion. And let me wish you well. We'll have the opportunity to come before you. I wish you all the best. Thank you.
Thank you very much.
I'll then proceed to give the floor to Honorable Practitioner Appiah, Deputy Minority
Thank you very
Leader.
much, Honorable Chair. Honorable Nominee, I've had a critical look at your CV, and it has actually exposed me to a number of things that I have ever overlooked. When you were giving us a brief about who you are, I noticed that I've always held the view that there's only one St. Augustine's school, and that's St. Augustine's Cape Coast, the college for which my brother and my leader attended. But it's good that you have exposed me that there's another one hiding here. Because when I was going through your CV, I was like, who in this world will leave St. Augustine's and go to Winneba Secondary School? That was my first impression about your CV. So I now get the difference between that. But my first question, since we're being watched and we have other people looking and following us, I wanted to find out why you did not complete your licensure course. Maybe it will inform people out there, people who want to undertake such courses. Maybe if you can give us a little detail about why you abandoned it. Thank you.
Thank you, Mr. Chair. Madam Member, I think I did because I found out that I'm more of an advocate than academic at the time. And I found out that the courtroom was rather my calling rather than the classroom. So when the opportunity came that I migrate to Canada, I think I chose to migrate to be a practitioner rather than academic. Thank you.
Another observation I made on page 4 of your CV was about your national service history. You happen to have 2 different engagement, or I should say employment, within the national services. Your first one was at Wasa JSS, Wasa District for national service, and the second one was Ackaah-Boafo PDC office. What were you doing there? Thank you. PDC office. Yeah.
Thank you, Madam Member. As you can see, there are 2 years. Unfortunately, I'm not so brilliant in maths. So my O-level maths was aggregate 7. And I couldn't, so I had to redo it. What it meant was I had to do 2 years post-A-level national service before going to university. So that is why you see 2 places there before my university.
Sorry, what is PDC?
Well, at the time, I was from the Wasa West District in Takwa. So I think these were organizations during the revolutionary days. They called them public defense committees. So national service persons like me and some from the university were placed there. They were taking complaints of people, and we became their clerks, writing notes for them. Thank you.
Right. Thank you very much, Honorable Chair. I know that we as individuals, we have our own affiliations, we have our religious ties, and sometimes we have our own extracurricular activities. And as we speak now, I know that you may be holding membership in some political organizations, religious, and some other businesses. May I know what could compromise your impartiality when it comes to giving judgment in a particular situation where your association, as I have already indicated, matters? Thank you.
Thank you very much. Let me put it on record that I am not affiliated to any political organization. I'm not affiliated to any business as of now, apart from me being a member of the Full Gospel Businessmen Fellowship International. But I think impartiality and conflict of interest come in handy if a judge takes the position that his or her views will be challenged in terms of what is placed before you. Let me put it on record that I actually had opportunity to write an opinion against my own brother's law firm. I proposed to the panel that I wanted to recuse because I know my brother. They said, well, but it's not his personal case. And I happened to write a judgment, and he lost. So I think it comes down to one's personal integrity as to whether or not you think you are conflicted. And if you strongly believe so, you must quickly and immediately recuse yourself. Thank you.
Thank you very much. I listened to your answer on the reintroduction of the public tribunals. And I was wondering, why are we not looking at ADR, which is Alternative Dispute Resolutions, and we are only looking at the public tribunals? Would you please explain clearly why the difference between the two? Thank you.
Thank you very much, Mr. Chair. I think ADR is already part of our justice system. In many courts, you have ADR offices, and they deal with civil matters the more. If I understand it, the whole idea of public tribunals, their jurisdiction was more of criminal matters, so that the two are not the same. ADR, by the virtue of the fact that we have the ADR Act, and many Ghanaians are using it, which is one of the best ways to help decongest the courts. And in ADR, the parties must agree. If you are being prosecuted by the state, I'm not sure you can say that states, please, let's go to ADR, unless after you've been charged, you take the position that you want to engage in a plea bargaining. So I think that is where the difference is. Thank you.
Thank you very much. Honorable Chair, I have one other interest. Would you agree with me that public trust in the judiciary is declining partly due to perceived politicization and corruption? How do you intend to contribute to restoring confidence in the judiciary, if approved?
Thank you, Mr. Chair. I think the judiciary, as I said initially, ought to be the integrity of the land, ought to be the arbiter of the land. So that if the judiciary is perceived to be corrupt, it is bad. But Madam Member, I want to say this. We seem to create the impression that the moment people get into the judiciary or some institution, they then become corrupt. I think there are serious philosophical questions for all of us as Ghanaians to ask. Because we must be corrupt before we join these institutions. So I think we should have that deep introspection as a people to understand, are we really corrupt? If we are, then we need to address it, rather than placing it in sectors and in institutions like the judiciary. I've heard many of my senior colleagues say there's the judiciary and the judicial service. That is a fact. So any perception of corruption is bad. But I think the time has come for Ghanaians to have that deep introspection, that people don't become corrupt because they've joined the judiciary or they've joined the police. We must all find out, are we men and women of integrity? Thank you.
And my last question. May I know from you, what is your legal and moral perspective on child marriage and witchcraft accusation as it stands now? Thank you.
Thank you very much. I think that the girl child should have the opportunity to be educated. The girl child should have the opportunity to develop her talent, so that placing any child into a marriage against their wishes at a younger age is certainly no-no. But why are we in a globalized society 2025 still talking about witchcraft? I think that these are nuances that as a people we may have to address. We accuse people of being witches, and you find out what is the standard for making such determinations. So yes, I do not believe that children should be put in marriages at tender age. Every child should have the opportunity to develop her talent. And if there is a need for us to regulate that through law, I am all for it. But I think in many of these things, it comes through education rather than just imposing law. Thank you very much.
My follow-up on that. You do agree with me that no matter how you look at it, it's something that is still with us. And education and legal education itself has not even helped. We're getting rid of such perceptions and ideas. Don't you still think that regulation will help to address this need? Thank you.
Thank you very much. I think my initial question was not doing away with regulations at all. I think that we can have laws because, as you indicated, there are some people, no matter how much you educate them, their mindset will not change. So that if we ought to use the law as a whip to draw them in line, that is perfect. Thank you very much.
Thank you, Mr. Chair.
Thank you very much. I'll give the floor to the Vice Chairman, Honorable George Kwaku.
Thank you very much, Mr. Chairman. Justice Kweku Tewia Ackaah-Boafo. Mbona Juma. Na uti nkwaso.
Mr. Darcy.
Looking at your CV, in fact, I realized that you have quite a number of publications. You actually have publications, articles, and some presentations that you have done on quite a number of subjects, but legally related. The one that jumped at me is your opinion or papers you have done on African continental free trade, quite extensively. Now, so that's where I'm going to ask you a question to get your opinion on. You delivered a paper actually on dispute settlement on the African continental free trade. And my question to you is that, do you think, which is basically the subject matter, that African dispute settlement mechanism that the African continental free trade have developed at the moment is a hope for a much further integration of Africa? Thank you.
Thank you very much. In that paper, I actually criticized the legal mechanism. I criticize it because the system has followed the traditional one of making state parties standing, giving state parties standing when it comes to dispute settlement. And if I understand the African Continental Free Trade Area agreement, the thinking is to help individuals and SMEs to be the main players. And my thinking is that if they have not been given standing, then the challenge is if there is a dispute, they have to route it through their government in order to have this resolved. And I see that as a bit of a challenge. Having said that, we also know that the AfCFTA is anchored on the root of the World Trade Organization. There is a case called the Bananas case, where banana producers from Honduras and the rest sued so that the nations can come together to help resolve that. For our purpose, though, I propose that the mechanism may not, as it is, give only state parties standing. That is why Ghana, where we have the headquarters, our judges must be trained on the concept of the African Continental Free Trade Area, because many of the disputes may start from us. And if we don't understand the agreement, I think we may use our Order 25 to impose an injunction and the entire market may collapse. So as it is, it might not be the best, but it's the beginning. My hope and my desire is that the main players in the area may be given standing when it comes to this settlement. Thank you.
Mr. Chairman, with your permission, a question.
Please do.
I think I do agree with you. The African Continental Free Trade only came in at 2018, ratification in Ghana quite recently. There are a lot of dispute cases to come involving the 54 African countries if they all ratify. And I don't think the legal preparation, at least in Ghana, is adequate enough to deal with the dispute that will eventually come. Now, do you think that we will have to still take our cases to the international arbitration, or should there be an African molded arbitration for cases on the continent? Thank you.
Thank you, Mr. Chair. I think if we are talking about the African Continental Free Trade Area, the mechanism they have the dispute settlement panels, and then they have the appeals panels. And the thinking is that if there should be a dispute, this should be the means by which the dispute should be resolved. But as I indicated, the agreement gives only state parties standing, so that if Uncle Kweku's company is the one in dispute with a company from Kenya, then it's the state of Ghana that must be fighting for you. So that is where I take the position that the dispute settlement mechanism under the African Continental Free Trade Area ought to be looked at, should give the SMEs and individuals standing when it comes to this dispute settlement. But as we know, in many agreements, the parties themselves may have their dispute settlement mechanism, and so far as that is in their agreement, they are open to use that to resolve their dispute. But let Ghanaian judges be trained on the African Continental Free Trade Area, because we have the headquarters and they will come to us. And we ought to understand the market and how it will operate. Thank you.
I think I absolutely agree with you. Congratulations, and hope that you will start work on the bench soon. Thank you.
Thank you very much, Vice. We now proceed to give the floor to Togbi Osahi, Alexander Kwamina Aponumaki.